Hi, good afternoon. My name is Nancy Barnes. I'm a labor and employment practice group leader and a partner at the law firm of Thompson Hine. We're glad that you can join us today for our panel discussion regarding labor and employment issues during these uncertain times. We will be discussing a case study today, looking at issues that arise as employers struggle to manage employees both inside and outside the workplace during the pandemic, while complying with a new array of laws, regulations, and guidance regarding workplace safety, disability accommodation, and other matters. Before we begin, there are a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box, which is located in the control panel on the right side of your screen to submit questions. We will try to answer as many questions as we can at the end of the webinar, and if not, we'll try to follow up with you with an email addressing your question. In the handout panel, you can download a copy of the PowerPoint slides and bios of today's speakers. We also have applied for 1 hour of CLE credit that has been requested and is pending in Ohio, along with HRCI credit. The CLE tracking code is located on the last PowerPoint presentation slide. Your attendance affirmation form can be downloaded from the handout section of the control panel. Submittal instructions can be found on the form. Everyone will receive a certificate of attendance once you submit your affirmation form. If you're seeking CLE in another state, you can submit the certificate of attendance for individual credit with that state. Again, thank you so much for your interest and your patience and for joining us today. And if you have questions as we go along, please use the question box. I'm delighted to turn this over for a minute to Jen Klein with OCTC to make a few welcoming comments. Jen?
Great, thank you so much. Good afternoon, everyone. I want to thank Thompson Hine for partnering with OCTC to provide this free webinar. Just as a brief background for those of you not familiar with OCTC, we are the trade group representing the interests of the chemical manufacturing industry here in Ohio. As the third largest chemical manufacturing state in the U.S., many do not know that, Ohio's industry has been incredibly active during this time, making the countless products needed to support health and good hygiene. They've also contributed significantly in their communities through product and monetary donations. And while the industry is busy doing all of that, they're also ensuring the safety of their workers and compliance with all regulations. None of that stops ever, even for a pandemic. That's why we're so thankful for Thompson Hine for presenting this case study, looking at issues that have arisen, complying with the plethora of laws, regulations, and guidance that are in place and that have been put in place since the beginning of the pandemic. As we continue in a virtual world, OCTC is looking to continue hosting monthly free webinars on topics important to you. We've been doing that here for most of the year. If you have any topic ideas, they do not need to be COVID related. COVID, non-COVID, just anything that you'd like to hear more on, please reach out to us. We anticipate quite a few regulatory matters as we enter a new administration, and we'll closely be following those to inform and engage our members. We're currently working on identifying January and February topics and webinars. So please, again, reach out to us if you're interested in speaking or have ideas. Again, thank you, Thompson Hine. And with that, I'll kick it back to you.
Great. Thanks so much, Jen. And I'm delighted to introduce my colleagues. Joining me today are two of my partners. Debbie Brenneman is a partner in our practice group who is resident in our Dayton and Cincinnati offices, as well as Scott Young, who is a resident of our Cincinnati office. So we will go ahead and get started with the presentation. So as many of you know, 2020 has presented unprecedented challenges to the workplace. Anybody who's been dealing with employment-related issues this year knows that we have a ton of new laws, statutes, regulations, evolving interpretations of laws that existed pre-COVID, a lack of guidance from courts at this point with respect to how COVID is going to be dealt with under that array of new laws, regulations. We also have health and safety issues that Jen referred to, which of course are front and center and always have been front and center, but really are getting a special emphasis with the pandemic. And then there are obviously requirements for basically immediate changes in implementation with respect to some of these new laws. So today what we're going to do is, and we hope this is helpful to you, is we're going to walk through a fictional scenario at the ABC company as it tries to deal with these issues that have arisen in the era of COVID. And we have some quiz questions for you, which will hopefully keep you awake and make the presentation more interesting. So we invite you to please participate as we go through the quiz questions about these scenarios. So to give you a little bit of background with respect to the scenario we're going to be dealing with, we are dealing with ABC Company, which is a manufacturing company headquartered in Ohio, like so many other companies, with operations in 10 different states. Its Ohio home is home to its administrative offices and headquarters, as well as a manufacturing plant. ABC has 150 employees in Ohio and more than 400 nationwide, as well as temporary employees who are placed there periodically by a staffing agency. And so as we go through this scenario, we have some characters. Susan is age 45. She's the VP of Marketing. Alex is age 62. He's the general manager and plant manager for the Ohio facility. He is salaried and he's worked for the company for 20 plus years. Tyrone is age 35. He's a bookkeeper in our finance department. Jackie is age 55. She's a new hourly employee in the plant. And Michael is age 20. He's a temporary employee from a staffing agency. So let's talk about leave issues. This is certainly something that has come up quite a bit as we've been dealing with COVID, and frankly, as we expect there to be more issues with COVID, particularly as we enter the winter months. ABC is anticipating that Ohio may implement further restrictions on its operations this winter due to COVID. It is an essential business manufacturing PPE, and its factories have been operating almost continuously since March. In July, the administrative workforce mostly returned to the office with barriers installed and social distancing guidelines in place. Tyrone has been working from home, that's what WFH means, this entire time due to a pre-existing condition. Susan just found out that her granddaughter's school is going virtual next week. The granddaughter, Lily, lives with Susan, so she has requested an accommodation to work from home until the school returns to in-person classes. She needs to work a split schedule so she can provide attention to Lily in the middle of the day. Susan asks her boss to allow her to work from home 5 days a week and to have a schedule where she works from 6 to 10 a.m. and from 3 to 7 p.m. And just as a reminder, Susan is our VP of Marketing. She's a salaried employee. Her boss understands that Susan may be entitled to leave under the FFCRA, but questions whether the company has to accommodate the schedule request and continue to pay Susan her full salary, and whether any of these leave rules apply to a granddaughter. So here's our first quiz question. Does ABC have to allow Susan to work from home under these conditions? A, it depends on whether Susan has formally adopted her granddaughter. B, it depends on whether Susan can perform the essential functions of her job working from home. C, no, this request is not covered under the FFCRA. Or D, yes, if Susan is loco parentis to Lily and she is under age 14. So I'm going to launch the poll here and ask you guys to participate by voting on which answer you believe is the correct answer. And then we will share that with everybody and discuss the results. And it looks like a number of you have voted. We're still waiting to see. I'd like to have everybody participate. It makes it much more interesting if we have a variety of answers. So it looks like more than 2/3 of you have voted. So we'll go ahead and close this. Okay, and I will share the results, hopefully. Share, here we go. Okay, and so let's look at what our answers were. First of all, the first answer deals with whether or not Susan has formally adopted her granddaughter, and nobody said that that's the test for determining whether or not Susan is entitled to work from home. And that's correct. That is a bad answer because formal adoption is not going to be the standard which is applied. With respect to B, it depends on whether Susan can perform her job from home. Well, do they have to let her work from home under these conditions? Whether she can work from home or not work from home, she is going to be entitled to either an accommodation, or if they can't accommodate the schedule change, then to allow her to work from home, because this is going to be a circumstance that is covered under the FFCRA. C, no, this request is not covered under the FFCRA. So let's talk about that. Susan is asking for an accommodation, a schedule switch, in order to allow her to supervise this granddaughter who lives with her. And let's think about what the FFCRA is. The FFCRA, among many other things, provides for leave under it's an amendment in some ways to the Family Medical Leave Act. And what do we remember about the Family Medical Leave Act? The Family Medical Leave Act does provide coverage for individuals who are in a loco parentis relationship to a child, or potentially an adult child, depending on the circumstances, and it doesn't require some sort of formal adoption or actual parental relationship. So the best answer is actually yes. D, if Susan is loco parentis to Lily, and the facts kind of suggest that she is because she's living with her, and she's under age 14, and you may remember that that's the critical cutoff in terms of leave related to caring for school-age children. If the child is 17, there's sort of an assumption that that child does not need the supervision of the parent, as opposed to someone who is under age 14. So D is your best answer. Okay. Next quiz question. Can ABC cut Susan's pay because she is working limited hours each day? A, no, Susan must continue to receive her full salary. B, no, Susan should receive a portion of her salary and the other hours should be paid using FFCRA pay. C, yes, Susan is permitted to take leave, but partial day absences do not have to be paid under FMLA. Or D, yes, provided that Susan normally works more than 8 hours per day when she is in the office. So let me launch this and give you a chance to vote. So we're covering some FMLA issues, FFCRA issues, FLSA issues. So we've got a lot of great federal laws that we can discuss in response to this question. So let's wait for a few more people to vote and participate. Okay, looks like we've got pretty decent participation. Let me close this and share it with you guys. Okay, so can ABC cut Susan's pay? Let's back up a little bit. Remember that Susan is clearly an exempt salaried employee. Her request is that instead of working 8 hours in the office, that she do a kind of quote-unquote split shift from home and still put in 8 hours per day. So let's look at the question. Can they cut Susan's pay? Let's start with D. No one responded D. Yes, if Susan works 8 plus hours when she is in the office. That is an incorrect answer. Nobody fell for that. And why is that the case? The case for that is Susan is continuing to work a work day. And as we recall under the FLSA, when an employee is working during the work week, has put in time and is working, and we'll put aside the FMLA exception at the moment, you cannot cut their pay because, let's say, for example, she's working 8 hours from home and maybe when she was in the office, she was working 9 hours. We can't dock her pay for that, alleged loss of an hour's worth of work. So D is a wrong answer. Can they cut her pay? Yes, FMLA permits partial day pay cuts. When does FMLA permit partial day pay cuts? Only in very limited circumstances that aren't applicable here, when it deals with someone who has medical issues that are not subject to a full day absence and where they've already taken that amount of time off. And so she's not taking partial day absences. So C is not a good answer. B, no, she should get a portion of her salary paid through FFCRA pay. Well, again, is she really taking time off, or is she simply just adjusting her hours? It does not appear that she is really taking time off, so B is not the best answer. A is the best answer. A few of you got that one right. She must continue to receive her full salary. So let's go on to our next scenario. Now, this is something I'm sure you've probably dealt with or you're hearing a lot about, but like here we have a recent spike in Cuyahoga County, and Jackie has become fearful that she is going to get COVID at work. She has had a few family members die from COVID, and she keeps hearing about Michael's weekend activities, going to bars and parties that demonstrate he's not taking COVID seriously. Jackie asks her boss, Alex, to give her leave under the FFCRA because her doctor has told her she has too much stress and it is unhealthy. Excuse me. In the alternative, she asks Alex to lay her off so she can collect unemployment. The plant is busy and needs all of its employees to meet its production demands. Is Jackie entitled to FFCRA leave? A, yes, because she has a legitimate fear of COVID and Michael's behavior is putting her at risk. B, yes, if her doctor gives her a written note saying that she is stressed. C, yes, if her doctor says that the stress is preventing her from performing the essential functions of her job and she needs leave. Or D, no, Jackie's request for leave is not COVID related or covered by the FFCRA. So let's launch this question and vote away. You guys are doing great. Oh, keep voting. I think people are falling for my trick question. Lawyers always have trick questions. So let's see how we do here. Okay, looks like we've got our votes in. Let me share the results with you guys. Okay, so is Jackie entitled to FFCRA leave? Let's go back and talk about the things that provide for FFCRA leave. They tend to be things where someone is diagnosed with COVID, someone is caring for somebody with COVID, somebody is waiting for their COVID test to come back and determine whether or not they actually have COVID. Is being stressed out or fearing COVID something that is provided for as a reason for leave under the FFCRA? The answer to that is no. So actually, the correct answer is D, that the request is not COVID related and it's not covered by the FFCRA. Let's talk about the answers that people provided. A, yes, legitimate fear of COVID and Michael puts her at risk. I mean, it's definitely true that Michael's behavior sounds like he may be putting her at risk, and that's certainly a headache that people are dealing with in the workplace. But a fear of COVID is not a basis for providing FFCRA leave. C, yes, if the doctor says the stress prevents her from performing the essential functions of her job. What is the trick that you guys fell for? You heard those magic Americans with Disabilities Act words and started thinking about, oh my gosh, is this a disability? Should we be accommodating it because she can't perform the essential functions of her job? And maybe you should. And you should go through that interactive process to determine whether or not she can perform the essential functions of her job, and potentially she may be entitled to some type of leave as an accommodation under the Americans with Disabilities Act. But at this particular moment, she is not entitled to FFCRA leave based on the facts that have been presented. So let's talk about e-learning. This is another headache. If you haven't dealt with it yet, you're going to be dealing with it in the next few months. Alex just received word that his child's school is going virtual. He and his wife both work, so they are planning to alternate days when they supervise their son, who is age 8, his schooling. Alex's wife works as a receptionist. Alex's boss, this is the general manager of the plant, by the way, questions why his plant manager is taking time off when his wife could supervise their son and be covered by a temp at her workplace. Alex's absence from 7 to 3 o'clock every other day presents an undue hardship for ABC. Alex indicates that he will work some hours in the morning and some hours in the evening, but he will need 20 hours of FFCRA leave each week. He typically works 50 hours per week. Alex has already taken 8 weeks of FEMLA leave this year for surgery that happened earlier in the year. So here's our quiz question. Assuming that the FFCRA is extended beyond December 31st, 2020, which PS, by the way, that is the current expiration date. We'll see what happens with that. Does ABC have to provide FFCRA leave to Alex? And if so, how much? A, no leave is required. It's an undue hardship for the company. B, no leave is required. His wife can care for their son. C, yes, he's entitled to 4 weeks of leave, 160 hours, because Alex has already used 8 weeks this year. Or D, Alex is entitled to 200 hours of leave. So let me pull up the question here and give you a chance to vote. Okay, we're getting our responses. And I'll tell you, this is a little bit of a trick. So if you think it's easy, you've probably not answered correctly. All right, so keep voting. Don't be scared. Nobody knows what anybody answers. We just know the percentages. So please participate. It makes it more interesting for everybody. Okay, I think we probably have our votes in. Let me share this. Okay, so does ABC have to provide him with leave and how much? Okay, nobody answered A about the undue hardship. Undue hardship does not apply to FFCRA unless you are a small business that can meet those exceptions, which we told you that ABC is a larger company, so that doesn't apply here. B, nobody answered that his wife can care for their son. That is correct. Although there are provisions that apply for the fact that if there's no, is there an additional adult who could care for that school-aged child? That is something that can be a criteria, but you can't pick and choose and say, well, one spouse has a less important job, so they should be the one who's caring for the child 5 days a week. So then most of you, excuse me, fell for the trick of C, providing 4 weeks of leave at 160 hours. That's what the remainder of his, what would be FEMLA leave, which is which FFCRA is a portion of that. But the problem is Alex works 50 hours a week. And so when you figure out how many hours is Alex entitled to, he works 50 hours a week, he's entitled to 12 weeks a year, he's entitled to 600 hours of leave. So when he takes 4 weeks of leave, he's entitled to 200 hours. So that's something that's really important when you're dealing with FEMLA on an intermittent basis, is you need to know how many hours a week does this person work, because that's going to control how much time they're entitled to under FEMLA. Okay, furloughs and pay cuts. This is obviously a big issue as well. Although ABC has had high demand for its products, it is experiencing a cash crunch because some of its customers are delaying payment. I'm sure nobody's heard about that. ABC is considering a number of options. Furloughing its administrative employees without pay every other week for a month, reducing all administrative salaries by 20% temporarily, forcing people to take their PTO so it doesn't have to be paid out at the end of the year, or some combination thereof. So let me, oops, I think I just messed up something with my polling, and my tech person's gonna probably kill me. I said manage polls. So let me go to the question. So here's the quiz. ABC's plan to do all of the above potentially violates A, the FFCRA, B, FLSA, C, Ohio PTO laws, or D, all of the above. So we'll let people vote away here. Okay, looks like we have most people have voted. And I clicked the wrong button, sorry. Thank goodness I have my tech person here, he's a wizard. Okay, let me close the poll. and share this with you. Okay, so here are the results. So 50% if you went with the lawyer answer, which is the all of the above answer, that is incorrect because, and the reason it's incorrect is because Ohio PTO laws, there are essentially no Ohio PTO laws other than there is case law which suggests that if somebody has PTO that they've earned and it's a termination and you have a practice of paying that out, you have to pay it out. But there are no laws, about the amount of PTO that has to be provided in Ohio or anything along those lines. So there's no violation of Ohio PTO laws, so both C and D are incorrect. Let's talk about FFCRA. Is there any violation suggested with the avenues that were provided in terms of furloughing or reducing? There's no implication for FFCRA. So the correct answer is FLSA. When you are talking about reducing salaries for someone who is an exempt salaried employee, there are specific steps that you have to go through in order to make those reductions, because the Fair Labor Standards Act says basically you can't be going back and forth constantly with somebody who's supposedly salaried to say, well, this week we're paying you $1,000 a week, but next month we're going to reduce that to $800, but don't worry, the month after that we're going to bump it back up to $900. That undermines the actual definition of a salary, which is that the person is being paid a set amount per week for their work, regardless of the quantity of hours that they work. So that's why there is a potential implication with respect to the Fair Labor Standards Act. Okay. Employee waivers. I'm now going to turn it over to Scott Young, who's in our Cincinnati office. Scott advises a lot of our clients regarding OSHA compliance and health and safety issues, along with a myriad of other employment-related issues. So I'm going to turn it over to him. Scott?
Yes. Good afternoon. The scenario that I'm going to initially start off with is an issue with employee waivers. Under this scenario, as the number of cases in Ohio spikes, the General Counsel begins to worry about the lawsuits she is hearing about related to employee exposure claims. The CEO is contemplating a year-end bonus to award workers in the factories. The GC suggests that maybe the workers should have to sign a waiver and release of workplace exposure claims in exchange for the bonus payment. And hence the quiz. Next slide. Should the company obtain waivers from its employees to prevent COVID-19 exposure claims? Yes, waivers are usually impermissible, but the company is willing to provide consideration in the form of a bonus in exchange for executing. No, all waivers between employees and their employer are illegal. Or no, these waivers are likely unenforceable in this context. This is a question that we get frequently, and certainly there have been some discussion around the country with respect to this issue, and we'll give some people some time to answer these questions. The poll.
Okay, go for it. Go.
And it looks like everybody is uniform in terms of how they responded to this question. And everybody answered C, and C is the correct answer in this particular situation. And that's because in the case of an employee that is filing a potential COVID exposure claim, if it is a true workers' comp type claim, then in order to be enforceable in Ohio, it would need to be approved by the state of Ohio in order to be enforceable. And if it's something outside of something that might be related to workers' comp, then the general rule on that is it's going to be void as against public policy. the next scenario is Jackie reports to her employer in Ohio that she has tested positive for COVID. Her employer does implement rules consistent with OSHA guidelines and applicable state orders to prevent COVID exposures and does endeavor to enforce these rules. However, there have been other reported COVID cases for employees at her facility, and she believes she was exposed at work because she is unaware of any other possible COVID exposures for her, as she is careful to maintain social distancing whenever in public. She files a workers' comp claim based upon her contraction of COVID and threatens to report the company to OSHA based upon the COVID cases at her facility. Although she recovers, Jackie was in ICU for a week with COVID. Hence the question. Is Jackie likely entitled to workers' compensation in Ohio based upon those facts? No, workers' comp does not cover COVID. B, not likely because Jackie will have difficulty proving that she contracted COVID at work in light of her employer's intentions to comply with OSHA guidelines and applicable state orders relating to COVID. No, the state of Ohio has insulated employers from all liability related to COVID. Or likely yes, because of the other prior cases at the facility, and Jackie is unaware of any other potential COVID exposures for her. People are answering. This is, I will be very curious to see how people answer, and I can certainly see various arguments for answering a variety of different ways. Okay, so we did receive some variances on the answers. I think everybody got it right that workers' comp, in terms of the answer with respect, nobody answered A. And then let's go down B, C, and D. So the next one is that we'll address. We'll skip A and we'll go to A, or go to C, because it's sort of along the same lines. No, Ohio has insulated employers from COVID liability. Ohio has, and in terms of the statute that everyone is referring to that would have responded to in terms of C, that Ohio has insulated businesses from third-party claims unless there is reckless or intentional misconduct, in essence, by the employer with respect to that particular issue. So with respect to an employer-employee claim with respect to COVID, that particular statute would not prohibit, in theory, a COVID claim. So C is not correct. Now, in terms of B and D, and B is probably the right answer in this particular case, and the reason for that, and again, I intentionally put some of the facts in there so that everybody sort of understands the test that Ohio will be looking at when they're considering a potential workers' comp claim. On the one hand, and this is why I could see why some people would certainly answer D, that is straightforward. She maintains social distancing, prior COVID cases, more likely than not, she perhaps sustained or contracted COVID at work. So that would certainly be the argument for D. However, there's another prong, so that everybody is aware, in terms of what Ohio would be looking at for purposes of whether or not the claim would be compensable. First, you'd have to look at, did the person sustain it? Can they prove more likely than not that she sustained it at work? And certainly the prior COVID cases would seem to support that. On the other hand, what I threw into the hypothetical was that the employer in this particular case, ABC, is endeavoring to both have rules and to enforce rules that are consistent with the applicable OSHA guidelines and state orders. And from that vantage point, the other prong of the test is going to be whether or not the employment environment created a greater risk than the public in general for purposes of contracting the disease. So she would need to prove both in order to potentially have a compensable workers' comp claim. And in this case, the compliance with the OSHA guidelines and state orders in this case, in my view, makes it probably B is probably the correct answer, but certainly can understand the debate, and this will be a heavily debated issue going forward. Next hypothetical. Employee litigation. Sally contracted COVID and she is threatening to sue the company for negligent, reckless, and intentional behavior because while it has rules in place consistent with applicable CDC guidelines and state orders, it did not actively enforce those rules. OSHA did an inspection and found that ABC had violated certain federal regulations for providing a safe workplace. ABC is worried that if it settles with Jackie, it will open the floodgates for, or it should be Sally, open the floodgates for claims from other employees. What potential exposure does ABC face in Ohio? None. Ohio employers have immunity from civil lawsuits based upon employee COVID claims. None. ABC implemented rules to adhere to CDC guidance and the applicable state order. It cannot be responsible for employees not following them. Significant exposure because OSHA found ABC to be in violation of its regulations. Jackie has a strong case. Or D, it is unclear based upon the facts in the hypothetical. Okay, we're getting a variety of responses. So from this vantage point, or from this hypothetical, the statutory immunity law that was passed in Ohio does protect businesses from a COVID exposure standpoint for anything other than reckless or intentional behavior. And then you also have the intentional tort statute in this particular case that would also apply. So based upon these, what I have given here, the answer is going to be either, I could see the argument being either C or D. And probably I would say, or rather the big question is, we put into the hypothetical that it did not actively enforce those rules. Now, was that the result of negligence? If it was simply negligence, then that isn't going to likely rise to exposure or liability. On the other hand, if an argument could be made that it was sort of intentional on the part of ABC, then you are correct that in that case, there certainly is potential significant exposure in that case. And again, even with respect to third party, which is for those people that would have answered A, that would generally apply to retail establishments, businesses that may have customers or contractors come in. And what that does provide is absolute immunity other than in the event of reckless or intentional misconduct. And in my example, it's certainly negligence wouldn't get you there. Negligence wouldn't get you there from a tort liability, whether or not I'm an employee or whether or not an independent contractor or customer. But reckless or intentional misbehavior, then third parties, the current statute that's in effect, that went into effect from March of this year until the end of September of next year, would not protect the business in that particular case. And then with respect to employee, the intentional tort statute still applies. And if you do have an OSHA violation and COVID or any sort of accident, that certainly does open the door for possible claims. Next situation. The next situation is going to be employee travel. ABC Salesforce has not traveled outside of its local area since March, conducting virtual meetings. The company believes that in-person visits are essential to maintaining relationships and will permit travel again. As a result, ABC is implementing a policy for its Ohio employees to permit business travel and require quarantine upon return from such business travel if legally required. The current rule in Ohio is that those entering Ohio after travel to states reporting positive testing rates of 15% Ohio or higher for COVID are advised to self-quarantine for 14 days. This is not a state mandate and is simply guidance at this point. In terms of the scenarios, Lucy is a salesperson whose written job position does provide for up to 50% travel outside of the state, but she does not want to travel because of her husband's health condition, where she fears she will contract COVID during this travel and make her husband sick. Sylvia works in the office as a receptionist and thinks that COVID is a hoax. She's going to Las Vegas. Currently, as of within the past week, it has a 16% or 16.4 positive rate. For a weekend, she has no plans to quarantine when she gets back because she has no PTO left. Lynda, who works in the same area as Sylvia, is worried about having to work with Sylvia when she returns from Las Vegas. With respect to Lucy, can ABC force Lucy to travel? It is a job requirement for her position. And remember, with her, it's the fear of her husband being sick and that he might contract it. The answer is yes. If it's an essential position of her employment, the EEOC has put out guidance with respect to that in light of the COVID pandemic, even if, hypothetically, her claim is legit, from a strict ADA position, the EEOC has indicated that even if somebody lives with a family member that could be high risk, that from an ADA standpoint, there's no obligation upon the employer to accommodate that particular situation. That said, certainly the EEOC allows for such accommodations to be made, and in that particular circumstance, one would also have to realize that if you do force Lucy to travel in that case, and she does develop COVID and comes back and makes her husband sick, then FMLA does allow or afford leave to protect somebody to take care of a family member that would have a legitimate disability. So that's certainly a factor to consider. The other factor to consider is, and this is a real life question that we've received, is, can the spouse sue the employer because they contract COVID from their spouse who does this business travel? Probably not, but the question has come up. So it's certainly from an accommodation. If you can make an accommodation, that's something to be considered. But from a strict legal requirement, it wouldn't be required. Can her refusal to travel be used as a basis for a PIP or a negative evaluation? If it's an essential part of her job and it's affecting her job performance, then yes. And likewise, if her ability to earn sales bonuses is lost because of her refusal to travel, is that legal? The answer to that question would be yes. The next scenario, Sylvia and Lynda. Lynda complains to her boss, Ebony, who supervises both Sylvia and Lynda. Lynda is refusing to come to work if Sylvia returns from Las Vegas to work, working in the same general area where Lynda is working. Lynda is a great employee and Sylvia is not. Ebony tells Sylvia that she should not go to Las Vegas, and if she does, she will be forced to quarantine for 2 weeks and will be off work without pay when she returns. Sylvia states that the rule is a violation of her constitutional right to travel. And from that vantage point, Sylvia travels to Las Vegas. Lynda threatens to walk out when Sylvia returns on Monday. What should ABC do? Fire Sylvia for insubordination, fire Lynda for threatening to refuse to work, put Sylvia on leave for 2 weeks, punish both Sylvia and Lynda for their behavior. The likely correct answer in this particular scenario would be to put Sylvia on leave without pay for 14 days from when she returns from Las Vegas. While certainly I see that a number of you answered punish both Sylvia and Lynda for their behavior, the thing to recognize is Lynda does have a right to a safe workplace. And if there is a view that you are subjecting her to an unsafe workplace, that could open up potential liability for an OSHA whistleblower claim, which is why D would probably not be recommended. C is the answer that we would probably give in that case. And next, I'll turn it over to Debbie.
Thank you, Scott. Well, let's continue talking through some scenarios. I'm going to give you a break from the quizzes, but I do want you to continue to pay attention and keep thinking about the potential solutions here. Obviously, we have a lot of people continuing to work from home with the spikes and just the change in workplace operation. That's probably going to continue to a much greater extent into the future than it ever has. So let's look at some scenarios. Susan, of course, who you remember is salaried and in marketing, Tyrone, who's hourly and in accounting, and James in sales, they're all working full-time from home because of COVID. They had all previously worked at an ABC facility. Susan has decided to work from her vacation home in Chautauqua, New York, instead of Cleveland, getting away from the Cleveland snow. But all of their bosses have concerns about this long-term work-from-home arrangement and have some concerns about their productivity and other issues. Next screen. Susan's boss actually wants to install software on her laptop, the company laptop, to monitor how much she's working each day. So he gets IT involved. They do this without Susan's knowledge, and her boss then confronts her with the information that he believes that she's only working about 25 hours per week. So he's very upset about this. He wants to discipline or fire Susan and thinks that the company should recoup some of her salary. Susan, on the other hand, thinks that this is a violation of her privacy, and she's up in arms about it. So what can we do from here? Next screen. Can ABC recoup or reduce Susan's salary? Well, Nancy spoke about salary reduction issues a little bit earlier. And similarly, you cannot, under the FLSA, reduce an exempt employee's salary because of performance issues, which is, what this is in one respect. You also can't reduce it because of a decrease in hours, and you're not going to be able to recoup that salary. So you have to deal with it in a different way. One way, should ABC discipline Susan based upon the information that it learned through its surveillance? Well, it likely could. One thing to keep in mind would be to look more at whether Susan is achieving the workplace goals that are set forth. If she's simply able to accomplish it in a fewer number of hours than the company may have expected, then maybe the solution is to increase Susan's workload rather than discipline her. But disciplining somebody for not working the expected hours would be an appropriate route. Because Susan's salaried, another option ABC wants to consider is requiring her to work a certain number of hours per week. Can the company do that without damaging the exempt classification? Yeah, there's nothing in the FLSA that prohibits an employer from setting an expectation with regard to hours or even tracking hours of exempt employees. But remembering, of course, that if Susan doesn't work those expected number of hours, you're not going to be able to dock her pay because of it. Now, what about Susan? Does she have a claim for invasion of privacy? In this situation, ABC policy does state that company computers can occasionally be used for personal matters. So does she have an invasion of privacy claim? Probably not. Certainly, it is generally permissible for companies to monitor computer activities. There is actually a variety of different types of technology that can do that. The most prudent way is to make sure that there's a policy in place, not only that says company computers can occasionally be used for personal matters, but that of course states that the company has a right to inspect or monitor activity on those computers at any time and without advance notice for that. Now, one caveat, of course, is that ABC should check the policies, local or state regulations that may impact those rights to conduct monitoring or place certain restrictions on it. Next screen. Let's talk a bit about protecting trade secret information and confidential information in light of all of this remote work. Tyrone, of course, has complete access to all of the company's financial information and records. He often accesses these materials on his personal phone and computer in addition to using his company laptop. And now that Starbucks has opened up, he sometimes works there because he's sick of being cooped up in his house. So what should the company be doing to protect its trade secret information? Let's look at that from a number of ways. Because Tyrone utilizes his personal devices, he's actually transferred many of ABC's financial and other data to those devices for his convenience when working remotely. What steps should ABC take to make sure its information is protected? Well, there are a variety of steps. I mean, number one, companies should be reevaluating what type of information individuals should be able to access, maybe placing additional parameters around what information can be accessed remotely, and certainly spelling out in policy and reminding employees what their policies are with regard to the transfer of data. ABC does fear that maybe Tyrone might be looking for other positions and becomes increasingly concerned about this commingling of information. Can ABC require him to permit HR to inspect his devices? Likely, yes, it can. Again, a policy is going to be very important to place that expectation that if you are using personal devices to access information, we as the company may be able to, we'll want to inspect that. In fact, to the next point, you can even require that the employee allow the company to install wiping software on those devices if they're being used for business purposes. Once again, very important that you have a policy in place that contemplates this and spells out this information and that's communicated to employees so that they are aware of that. Tyrone leaves Starbucks to go home to participate in a Zoom call with other members of the financial department. He takes the call to his kitchen table where his girlfriend is also working remotely. Has Tyrone now compromised ABC's trade secret information? Well, perhaps he has. We are beginning to see case law that does talk to this heightened duty in this new remote work world to alter how the steps the company is taking to protect the integrity of trade secret information. Remember, trade secret information has to be subject to reasonable steps to protect that trade secret information. And we saw a case a couple of months ago out of Delaware where the court reasoned that the company had lost the protection, the rights to protect its trade secret information because it did not have appropriate security measures around a Zoom call. The company didn't follow the Zoom protocol for security, and it also did other things like circulate access codes for that Zoom call without confidentiality agreements and without monitoring who was on that Zoom call. So that case reminds us that we now need to take a look at it. People are working remotely. We don't know who else is working in that environment. We can't see what all they're doing with the trade secret information. So it's important to reevaluate trade secret policies and protections in light of this work from home situation that we're all encountering now. Next screen. In taking a look at that, actually, before we go into some of the other steps, let's talk about the fact that James is a primary contact with ABC's most important customers, and he has full access to those data. He works in California, but now he's taken on some customers in other states as a result of COVID-related downsizing of ABC's workforce. Now, because he's in California, the company never had him sign a non-competition agreement because, of course, those things are not enforceable in California, but it really is reevaluating things now. So what can the company do at this point? Next screen. Can the company have James sign a non-compete with regard to his work in those other states? Well, maybe. Likely it's still not going to be enforced because he is in California. and they would have to get an order in California to enforce it. But it is at least probably worth reevaluating those agreements. There might be an opportunity that he moves. Certainly there's a deterrent effect. But certainly the company wants to make sure that there is a very healthy confidentiality agreement in place with James. And the company also wants to make sure that it is strengthening its protection of trade secret information because James does have this access to this full panoply of information. So what can the company do in that regard? Well, some things with regard to the protection of trade secret information have not changed. Companies still want to do the basics. Use firewalls, use passwords, limit access to documents and information. But the company also needs to think about some other measures now. Next screen. Home security measures, for instance, are critical. Companies can and should require their employees, if they are working remotely, to establish home security measures for their home internet system. Make sure those networks have Wi-Fi passwords and limitations, and work with the IT department to consider a multi-factor authentication to log into a company portal. Next screen. Other things that employers could consider are monitoring policies. So monitoring the access and use of certain key data, the most protected proprietary and trade secret information. Some companies utilize routine monitoring just from time to time, taking a look at what employees are up to in terms of accessing data. They can also develop programs to use suspicious use monitoring. So if you've got somebody working remotely, you don't have eyes on them like you perhaps did, but you can have tripwires established. So if a employee accesses a certain number of documents in a day or in a defined period of time that would look suspicious, then the IT department can go in and take a look at what documents were being accessed, what happened to them, and the company can evaluate whether there was a valid use of those documents or maybe something's going on. Another type of monitoring is key data monitoring, which would flip a switch whenever certain very protected documents are accessed. And these are important things to consider with the increase of remote working. Next slide. Companies also want to make sure they are reviewing their handbook and policies to address this new remote workplace, including updated agreements, policies with regard to work at home, going as far as spelling out the fact that employees should not be working in areas where other people can overhear or see the documents that they are accessing, even addressing how documents and information are stored and destroyed in remote work environments. Next screen. And at the heart of this, really renewed training is key here. Remind employees of your confidentiality policies and any security protocols, especially these enhanced protocols. Remind them of their policies. Again, specifically and expressly advise them that they should conduct sensitive business activities in an isolated part of the home, away from others, not in a Starbucks environment. Train employees who use video conferencing services how to use those services security features, and establish your own security features for how to use video conferencing services. And also train and refresh employees on the importance of recognizing and avoiding phishing scams. We have seen an uptick in those types of scams with the remote working environment. Let's quickly go to another scenario with working from home. Susan, as you know, is working in Chautauqua. She notifies ABC that she plans to continue working from that vacation home through the first of the year, but that she will also be returning to Cleveland from time to time because there's some work being done on her primary home. Should ABC require Susan to inform the company of her location on a daily or weekly basis since she is moving around a bit? Actually, yes, the company really should make sure that employees are keeping them aware of where they are actually performing their work. There may be different state tax or withholding issues, even on a local level, depending on where employees are. The company may be subject to more restrictive meal break or other workplace policies, including required trainings, depending on where the employees are. And there could be additional reimbursable expenses for home offices. California, for instance, has a number of express rules regarding home office reimbursable expenses. So it's important the company knows exactly where Susan is going from time to time. One last reminder on handling remote hiring and onboarding is make sure that you are thinking through and establishing policies for how you conduct hiring and onboarding in a remote environment. Make sure you are finding ways to meet your I-9 compliance, and think about converting some of your training modules and webinars to online modules so that your new hires don't skip over those training, that you're accurately tracking those trainings, and even meet and greet and getting to know you type of modules for those employees can be very helpful in integrating them and in making sure that they get to know their new remote work colleagues. And I think that brings us to about the end of our time. We may have a moment or two for any questions that have come up during our presentation.
Yeah, thank you so much, Debbie, and thank you, Scott. We are at the end of our time. I know we got a late start. Thank you so much to everybody for your flexibility. If you do have questions, feel free to email Scott or Debbie or me with any questions that you have. This is our CLE tracking code, which we talked about for those of you who are applying for CLE credit. This is the code that you will need on your form. And again, those forms are in the handout section of the toolbar if you are planning to apply for CLE credit. If you're not currently receiving our updates and invitations from Thompson Hine, we welcome you to go to our website and register to receive our mailings under the Publications tab. Thank you so much to everybody who attended today. We hope that this was helpful. And again, we appreciate your flexibility and patience. Enjoy the rest of your day, and please stay safe and stay well, and enjoy the holiday season. Bye-bye.